Record. Hey guys, sorry, I have to mute myself. The baby is making too much noise. Oh, I actually see some participants already here. Shirley, do you mind switching to that the third slide, please? And I think everybody heard that I said the baby was loud. Sorry, I didn't know that people were in the room. Okay, perfect. Yes. Okay, perfect. Let's wait for another 5 minutes and then we can get started. Okay, 7. Let's give 5 minutes, then we get started. Oh, somebody just messaged, can't hear. We haven't started yet. We're giving 5 minutes. So 3 more minutes, then we're gonna start. Shirley, do you wanna put the slide back to the third one? We'll do the other one when we start. Okay, great. So guys, if there's any questions, just type in the Q&A box or type in the chat. As we go along, we try to answer it, because today, like, we have a lot of material to go through, so we'll box it pretty tight because we have a hard cutoff. So just yeah, any questions? Just type it up. So give another 2 minutes, and then we're gonna start. Okay, 1 more minute, then we're gonna start. One more. It's 1 more. Darren, are you on the line?
I am here.
Great. Okay, we'll give it another minute and then we'll get started.
Okay.
Yeah. Oh, actually, before we start, question. Darren, do you want to open your camera, or do you want to?
That's fine.
Oh, okay, okay. Because I think it's better if people see your face. That's
yeah, I can't start it because the host has stopped it.
Oh, gotcha, gotcha. Okay. So, Shirley, do you mind giving Darren that authority to show his face? Lovely face. Okay, we're getting ready to start here. Yeah, there's enough, like there's a good group here. I know there's still other people who joined, but didn't come in yet, but we'll get started. Okay, Shirley, do you want to give Darren camera access?
Yeah, I'm trying to find the option. Just 1 moment.
Got it. Yeah. While we are figuring that tech part out, Shirley, you know what? Move.
Darren, can you try? I think I just open your camera.
Yep, I saw it. All right, there we go.
Great.
Perfect. Okay, okay. Now, Shirley, can you move the slide to the? Can you start? Yeah, let's just get started. Okay, everyone, thank you for spending the evening with us today. I can guarantee you that you're gonna walk out of here with a lot of knowledge, and you can start making money immediately. All right, like this is one of those rare events that you are able to do that. Okay, but again, we're gonna share everything that we know of, and particularly from Darren, the lawyer himself. So if anything, you're gonna learn a ton tonight. All right. So before we start, just some house cleaning stuff. Next slide, please. Okay, so the information provided here is for educational purpose only. All information provided here is provided in good faith. However, we make no representation or warranty of any kind expressed or implied regarding the accuracy, adequacy, validity, reliability, availability, or completeness of any information provided. Under no circumstance shall we have any liability to you for any loss or damages or any kind of incurred as a result of the use of the information shared here or reliance on any information provided here. Your use of the information and your reliance on any information provided here is solely at your own risk. Okay, my lawyer told me to say that, so I said it, and that's good. Let's get that out of the way. All right. So we're here today because so we are a small firm specializing in passive income, right? We have many different products. Lending is a big part of what we do, and it's a very popular one. We also do real estate, which so we thought it's good to put everything in one slide so you know what we're talking about today. What we're talking about is on the left side, which is the lending. So legal lending, which Darren, the lawyer himself, is going to explain everything today. The minimum fund required is only 10,000, turns 6 months, and interest rate is annually 10% plus sometimes, and it's fully prepaid. Now, that's what we're going to talk about today on the left-hand side. On the right-hand side is other options when you have more capital. So we also do duplex, triplex. You need around 300K to 500K, roughly. You need about a year to stabilize the asset so you can run on its own, and you can earn about 40 to 70 estimated year rental income. You can qualify for a bank for about 5 to 10 of these, and then you will get into multifamily if you have like 1 million plus cash on hand, and you need about 24 months to stabilize the building so you can run on its own, and you can earn over 70,000 annual estimated rental income, and you can qualify for commercial mortgages, which you don't have to qualify on your income. You can buy unlimited assets. So we're not talking about the right-hand side today. We're talking about the left-hand side, which is the lending. So you can see the dramatic difference, right? The minimum fund required is much smaller, the turn is much quicker, and the rate is attractive in today's environment. I personally put a lot of money in this with Darren, just because we've known each other for a long time, and because of everything that he will explain to everyone today. But that's my decision, and that's my decision only. So we want to provide this information for you so you can make your own judgment and make your own decision regarding whether you like this kind of passive income or not. All right. So without further ado, let's hand it over to Darren. So let's get started. What is legal lending?
I'll go through the slides and answer the questions. So to answer what is legal lending, I'll have to back up a bit in terms of what I do. So I am what's called a personal injury lawyer, and I represent clients who get injured and defendants who are represented by insurance companies, and we bring lawsuits and get them compensation. Now, as part of that process, I, as an injury lawyer, fund the entire litigation for the client, so the client does not have to pay anything during the course of the litigation. And I take my fee at the end when the claim settles, and I get a percentage of what we settle the claim for. But in addition to that, which is what's most relevant to the discussion here, is that I also fund the disbursements for the client, or the disbursements for the claim. And those disbursements are typically the smaller cost, as an example, for things like court filing fees and photocopying costs, courier costs, things like that, but also the more significant costs, which tend to be the clinical and medical aspects of the claim, and in particular the engagement of experts, which can cost exorbitant amounts of money to get the proper experts. Experts can charge $5,000, $10,000, $15,000 to prepare reports on various claims. So legal lending sprung up to essentially assist lawyers such as myself to essentially do that, to pay the disbursements along the way. So the money is lent to the lawyer, and then the lawyer disperses the funds on the files and covers all the disbursements for the claims. And then when the claim ultimately settles, the money that's been spent out on the disbursements is recouped and recaptured and comes back. And then is brought back into what I would call the sort of the launching pad account, at which point it can either be put out again for other files, or it can be paid out back to people that have lent money in. So legal lending is essentially lending money to a lawyer such as myself so that I can execute and put money out on disbursements on all the files as they are progressing along.
Okay, so one point of clarification for somebody who like me, who doesn't know legal terms, like what does disbursement include? What are those reports like for? Like is
yeah, sure. So like I say, the main ones are the reports. So as an example, if it's an injury claim, which the majority of them are, You're going to have reports that are going to deal with whatever that injury is. You may want to get a report from an orthopedic surgeon. You may want to get a report from a family doctor. You may want to get a report from a neurologist to essentially say what's wrong with the person, because in the system that we work within, you require those reports to go to court ultimately and prove whatever the injury is. You just can't walk into court and say the person's got a certain problem. You need some expert to say what the problem is, what the prognosis of that may be, and you have to engage and pay an expert to actually say that. And so we get those reports for that purpose.
So it's doctor's reports, and then you have to pay for those because you're not taking any retainer from the clients. Okay.
Yeah, that's correct. Pretty much. Doctor reports can also be like things like economic reports as well, which will project somebody's income loss as an example or something like that, but primarily medical reports.
Okay, got it. Next. If people have questions, raise your hands or put in the Q&A, whatever. We'll try to address it along the way, but okay, next.
Why does legal lending exist?
Why do you make money? Why does it exist?
It exists because when you, if you're a successful personal injury lawyer, you start to become what we say in the business, you get to become a victim of your own success, which means that you get more and more files, which is good because you're going to make more and more money as those claims settle. But the problem is you have to put out more and more money to operate and put those files out there, because if the average file requires disbursements of around $20,000, if that's sort of the average at any one point in time, for every 100 files that you're operating, you have to have $2 million out at any one point in order to successfully operate those files. So if you get 200 files, suddenly you've got to put 4 million out, and if you put 300 files out, now you're up to 6 million. So it keeps going up and up and up and up. And if you're somebody like me, who runs close to approximately 800 files at any one point in time, you start to get up into the 14, 15, 16 million range of money that needs to be out there. So of course, to help with that, legal lending sprang into existence in terms of advancing money to the lawyer, lending money to the lawyer, so that the lawyer could put that money out on the files and therefore continue to operate as not, again, as I said, a victim of his or her own success, to the point that they would actually stop taking on new files simply because there's too many and too much money would have to go out. So it allows us to continue to grow, so to speak, and expand and take on new files as they come in.
Okay, great. Next one. Who are you, Derek?
Who am I?
Why should I lend money to you?
That's right. So, first of all, anybody, if you want to Google me, obviously people can feel free to Google my name. So I've been a personal injury lawyer for personal injury specifically for about 25 years. I was an associate at a personal injury firm for many of those years, then became a partner at that firm, and then ultimately a more national injury firm came to British Columbia, which is the province where I'm based, and sort of recruited me to associate with them to help them grow their business in BC, and also gave me an opportunity to practice not only in BC but also in Ontario and Nova Scotia, where I also have claims. So that's me. I've done many trials, settled many claims, negotiated some of the largest settlements, and have been in the appellate courts. I've been in the Supreme Court of Canada a couple times successfully. So I've been around the block, so to speak, more times than I would like to admit, but it's been about 25 years since I've been here.
Okay, and I think you also had 2 landmark ruling at the Supreme Court of Canada, which changed the law, right?
Yeah, that's correct. Yeah, I was, as I mentioned, I've been in the Supreme Court of Canada twice, and I won both times. But by winning, because I tend to represent plaintiffs, I don't represent defendants or insurance companies. We tend to be bucking the status quo when we're fighting. So both times I was able to win, and the national law changed to make it a little more, I think, fair for people along the way.
And I think you're on TV quite a lot. We have some TV clips that you were interviewed on CTV, whatever. If people are interested, reach out. We can share that with you.
Yeah, I've been on. If I say on YouTube, I think there's a few. I mean, there's been CTV, there's been Fairchild TV here. I think Global might have done something at one point as well. I've been on a few television interviews, as well as there's some articles out there as well. Occasionally, one of my cases gets media attention, and it may or may not mention my name. Sometimes it does. Sometimes it just talks about the client. But if you Google it, you'll get a number of hits on that.
Okay, great. Next, I don't see any questions so far, so let's go next. Why are we only doing legal lending in BC?
BC is a very user-friendly environment for it. Some jurisdictions have restrictions on the way that lawyers can fund the disbursements. Some of them have restrictions, some of them, quite frankly, have restrictions on not allowing them to fund the disbursements. Others have restrictions on what disbursements can be funded. Others have restrictions on how much disbursements can be funded. BC is essentially wide open for that. There are no restrictions at all on a lawyer funding the disbursements on a particular case. There's no limitations as to how much money can be funded on there, and there's no limitations on where that money may potentially come from. In other words, it doesn't have to come from the lawyer individually. It can come from the lawyer borrowing money from another source to fund those disbursements. So it's the easiest jurisdiction to do that at the end of the day, because of the fact that there are no bureaucracy involved in doing that kind of work.
Okay. Also, is there a difference in law between, say, Ontario and BC in terms of like how safe the disbursements are going to be recouped?
There other jurisdictions they can be a little harsher if things don't go as you expect in court. Like Ontario can be quite harsh on disbursement recovery if things are not working the way that you necessarily would want them to work out. I think BC is, again, a little easier for that, and it tends to be more of it. The way the system is set up is the insurer in these cases, who are representing the defendants, is supposed to, at the end of the day, and as part of any settlement resolution, supposed to pay the full disbursements in addition to whatever they're paying by way of settlements. Other jurisdictions sometimes have, again, some restrictions on that. They only have to pay a certain amount on certain disbursements. BC tried that recently to, and I say BC, I mean the government tried to potentially have some restrictions on motor vehicle accident claims in terms of what you could claim. And that was rejected and defeated in court. So we don't have that here, but other jurisdictions do. So there may be more stricter regimes in terms of what you can recover in other jurisdictions.
Okay. Now, my follow-up question on that is, then that's in theory. In practice, is that the case? Like in BC, like do people usually get the full disbursement bounce back on top in addition to the
Yes, yeah, all the time. I've never had an issue with it. Everybody understands that's the way it works, and that part's never the issue. The issue in settling a claim is never recapturing the disbursements. It's whether or not you're getting a fair settlement for the claim itself.
Right.
In addition to the disbursement, that's always the issue.
Right. Okay. Next. Okay, why do you have so many cases compared to other lawyers? Because whenever I mention this to my other lawyers, like, wow, that's so many cases. That's so many cases. How can you handle so many cases?
Yeah, it's a good question. I mean, I've always had more cases than other lawyers have had. I think I have a well-dedicated and well-trained team, if I can use that word, of people that work underneath me to assist with that. And once you know what you're doing with injury claims, they pretty much all operate in the same way. And they pretty much all work their way forward in the same way, and they're spread out in terms of when trials are, and they're spread out in terms of when what are called discovery, which are questionings are. So you can handle quite a few if you have an appropriate system arranged, particularly in today's technological world. I mean, everything is on computers and iPads. I mean, I have everybody's file accessible to me on my iPad, including every single document that they have, which of course didn't have 15 years ago. Example, yeah, you needed the paper. So it is much easier to operate in that respect now. Now, the other thing that happens is because I've been around so long, I do get an awful lot of referrals from previous clients. I don't like to turn anybody down. So provided they have a viable claim, I'll take them. I personally just feel bad about referring someone to somebody else. So I will take the case and keep it. Also because of the age I'm at, which is 57. There's a lot of the lawyers that I sort of worked against over the years who are about maybe 10, 15 years ahead of me. So they're approaching their late 60s to 70, and they're retiring, a lot of them, and they want to hand off their ongoing files to somebody they can trust, and somebody that they know their clients will be in good hands with, and somebody they know that will not, quite frankly, screw them in terms of giving them some share of the fee when the claim settles. And so I get a lot of those. So I often will get like an influx of 50 files at a time or 100 at a time coming from a different lawyer who happens to be retiring and doesn't want them anymore. And so that tends to happen, and that's why they build up to such a level. But again, it's a systemic thing. As long as you have the system in place to operate, it seems to be manageable to do, again, particularly given the technology that we deal with these days.
Great. How many people do you have?
From working for me personally, I have one lawyer works for me, and then I have 2 case managers, and then a paralegal under that who handle all of those. They kind of handle the more, I guess, mundane day-to-day matters, if I can call it that, and then I deal with the more the upper level matters, like the actual negotiations, the settlements, and if necessary, a trial. So it kind of works its way up the food chain.
Great. Okay, next. Okay, how are the lenders protected?
It's kind of it's kind of a 2 stage protection. I mean, first of all, there is the files that I use the money for. So the files where this money is dispersed are what I classify as the sort of safe files, which are, quite frankly, most of the files I have. And safe files are ones that have 2 important components. One component is that the liability is not an issue, or not a serious issue. Liability is essentially fault. So if somebody's been injured and sues another party for causing that injury, they are going to get compensated for that, as long as the other party is in some way at least partially at fault for what had happened. The other party doesn't have to be fully at fault. They only have to be partially at fault in order to at least get some compensation. And why that's important for disbursements is once you get some compensation, even if you're only getting a portion of it, that triggers the insurance company having to pay out the disbursements that we've paid on the claim. So the files that the money's being used on are in that category, so that I know the disbursements are always going to get recouped at the end of the day, and they always have been. But there's also a second layer of protection that exists, because we now have there's a product that was introduced on the market a couple of years ago, probably more than a couple of years ago now, called After the Event Insurance, which is an insurance policy that a firm can purchase. And essentially what it does is that if a claim were to fail for some reason, and the disbursements would normally be lost, the insurance company kind of comes in and pays out those disbursements to the firm to protect against those disbursements being lost. So there's a sort of a secondary, almost a safety net, that if one of those safe files fails, and they shouldn't, but if they were to fail, then the disbursements would be covered anyway. So the disbursements that are being paid on the files can't be lost in any particular way. They're either going to be recouped in the ordinary course from the insurance company that's defending the defendant in the lawsuit, or they're going to be paid by the after the event insurance policy if for some reason it's not paid by the actual insurer.
Okay, I also think, no, that's good. And I also think in the contract, at least that I signed with you, you also put a personal guarantee as well, right?
Yeah, that's right. I mean, obviously, because you're lending the money to me, and it's running through me, that obviously, if for some reason that money is not being repaid to you, that's you would be coming after me. Where is that money, so to speak? But from the actual sort of hardcore, where is the money kept, and is it going to go anywhere? It's going to be sitting in a file disbursement account somewhere, protected, either getting repaid at the end of the claim or funded by the after event insurance policy if it for some reason wasn't.
Okay. One last point I want to ask is, when you mentioned, like even if they just pay part of the compensation, the full amount of disbursement they have to pay, is that the same law in both BC and Ontario?
That's a good question. I don't have enough cases in Ontario to have encountered that, to know how Ontario handles that. In BC, it's depends on, it's a bit complex legally, but it depends on, generally speaking, if let's say the defendant's 25% at fault for what happened, the person only gets 25% of their claim value, but the disbursements that have been expended to prove that claim value are still 100% in BC. So that's why the disbursements get repaid back. In Ontario, I don't know, quite frankly, whether or not that same logic applies. Ontario has slightly different rules for how the costs are done, and I haven't encountered that yet in Ontario. Because quite frankly, in Ontario and Nova Scotia, I only deal with medical malpractice claims, which are different, as we've discussed, a different ball of wax from what we do here. I don't put anybody's money on medical malpractice claims because they're risky claims. So those are the only ones I deal with in those jurisdictions.
Got it. Great. Okay, next. So this is my favorite section. What are the risks? So for example, for me, when I look at this, really the biggest risk is you just take the money and gamble it. Like you don't put the money on the cases.
Yeah, and that is I think the most uncomfortable part for people. That is, and that's what I was going to say. I mean, I think from a risk perspective, assuming I am doing what I'm supposed to be doing, there really is no risk to the money itself, because the money is going to disbursements, which are either going to get recovered in some way, as we've already discussed. The only risk would be because it's a bit of a blind loan, so to speak. It's going to me, and then the good faith would have to be that it's going to where it's supposed to go at the end of the day, which is the same risk as an example a bank takes in the same situation, because they don't lend money to files, they lend money to the lawyer who then disperses the money on the files. The same system is in play. So that would be the really only risk that's going on. So I think if you're that would be the part that I think anybody might be uncomfortable with. And I think if you were dealing with somebody that hasn't been around very long, or somebody who moves around a lot, or something like this, that may be more of a concern. I think if you're dealing with sort of older, more experienced, pretty much been in the same location for the last decade or 25 years, it's probably a more safer bet. But that's something that people need to take into account on their own when they consider it, because that is the one area of risk for people, for sure. I mean, if I was sitting on the other side, that would be the one thing that I would be wondering about.
Right.
Is that very thing. I mean, they get a personal guarantee from me, and as we've gone over before, I mean, I live in BC, I have a couple properties in BC. I mean, I'm not going anywhere. So it generally, I think people are generally comfortable with it, but I'm sure there's been people that aren't comfortable with it and they haven't gone ahead, which is fair enough. I mean, I knock them for having that concern. But yeah, that would be the one area that people would have to consider when they're wondering whether to do this or not.
Right. And that's part of the reason, that's the part of the reason why we do these kind of seminars like every few months, so people can, meet you and judge for themselves, right?
Yeah, and that's what they would have to do, and that's what they would have to potentially Google and things like this just to get a sense of who I am and what my reputation is in the legal community, and whether or not that would be likely that I would do something like that.
Right. And also, we had this discussion because we thought of different ways to prove that, at least to show that the money is dispersed on disbursement, but like you said, some technical difficulties. Do you want to share that?
Yeah, well, it's the banks run into the same problems. I mean, we have the same discussions, or had the same discussions with banks before, when I used to use banks, and it's called solicitor-client privilege. I mean, nobody can know what anybody's file is. I mean, I cannot admit to anybody, who my clients are. I can't admit that what's going on in their case, or what's being spent on their case, or what their case is about. I am not permitted to have any such discussions. I mean, I can't even admit, like, say somebody has a case. I mean, this is not something I can do. So any of the money that comes in cannot be attached or tracked to any particular file, at least not in a way that anybody lending money can be aware of, because then they would be broaching into that solicitor-client privilege, because they would get somebody's name, or they would get somebody's case information, which they're not allowed to have. So they need to stay sort of outside of that bubble, so to speak, which is one reason why the interest rate has always been higher. I mean, it's not like a traditional 3% loan or something like this, right? The interest rate's always been higher to reflect that reason, that it's a loan that people are making, that they're trusting a certain portion of it to be working the way that they're being told it's working, which is why the interest rate tends to be higher on these sort of things, which is why the banks charge higher interest rates on these things as well, and other organizations that have sprung up at various points in time to try to jump in and lend money on these things. I mean, it's a fairly big business right now with not only banks, but a lot of sort of loan companies are jumping up to try to get in on it, because because the interest rate paid is high. And generally speaking, they're protected the same way lenders here would be protected with the after the event insurance and things like this. So it's a fairly hot commodity for people wanting to lend money on them, so long as they can get over the initial giving the money to a lawyer. I need to trust that lawyer to be doing with it what they're going to do, and that's what these other entities, these other companies do as well. They do their due diligence check on you, which is essentially Googling your name and asking around, and then if they're satisfied with that, then they go ahead and they do that.
Right. And just for people who joined later, the interest rate you're talking about is 10% plus. Okay.
Yeah, and plus as we know, I just pay it in advance to people, which I think obviously makes it a little more than that, but also logistically it's easier. So if somebody, as an example, wants to lend $100,000 or something like that for a year, just use a simple example, they basically lend $90,000, and then they get $100,000 back at the end of the year. So they make their $10,000 when the year's up.
Right. Okay. Great. I think we've done this section really well. Next. So how does it work?
How does it work?
I think the term, the rates, and the logistics.
Yeah, well, the logistics are, I mean, obviously the logistics are people contact you in terms of arranging the actual paperwork and things like that. But basically what happens is there's sorry, go ahead.
Just so everybody here knows, like, we help Darren do all the paperwork. So, we do the paperwork. We help Darren with that. That's why you have to contact us.
Yeah. So basically, once that's arranged and set up and the paperwork's in place, then people effectively just deposit money into the sort of central launching pad account, so to speak. And once that money's there, what I do with it is then I will then take it and I will start putting it out on files that need the money dispersed on. And then that money goes out there. Now, in any given month, obviously people's terms are coming up. So, if right now we're in June, so in July, there'll be a certain number of people who have lent money who their terms are coming up. And so when their terms come up in that month, they do a couple things. Some people will just basically roll it over, so to speak. So then they would get a check from me for whatever the next amount of interest would be, whether they're rolling it over for 6 months or a year, depending on what it is. Some people will want it all paid out to them at that point. So they'll get a check for me paying it all back to them at that point. And some people will sort of do a hybrid of the two. Some people will take some of it out, but keep some of it there. So they'll get a check from me for whatever they pulled out, plus the interest on whatever they've left. Some people will put more in at that point, and then that money just goes back in, and then again, I'll roll it back out for the disbursement. So it's a bit of on a revolving thing. So for any individual lender, they just really need to watch whatever their actual specific term is coming up, and then decide whether or not they want to roll over again, or whether or not they want their money out at that point. And then I just simply write a check for them to get that money out. So it's a fairly simplistic process. The money flows through that one launching pad account into the files, into the actual physical files, and pays the disbursements on the physical files. And then when they settle, it goes back in to the launching pad account.
Right. Okay. So I want to just recap, asking for people who arrive a bit later. So the rate is 10%. If the amount is more, you get more than 10%, but that's we do all the math. And turn 6 months. So for example, somebody just asked in the example where Darren decided, the contract's for 100K, people give you 90K, they get 100K back in 12 months. That's because the 10% is an annual rate. So if it's a 6 month term, you send 95K first to Darren, and in 6 months, Darren will give you 100K back. So it's 10% starting, and starting at 10%, and which is the annual rate, and the term is 6 months. And at every 6 months, people decide whether they want to renew or whether they want to redeem. So, and we just do the paperwork. Yeah. Okay. All right. Next. How do you work the files?
How do we work the files? So basically, explain a little bit how litigation works. It's for people's own education there. So if you have an injury claim, what your lawyer will typically do as soon as they get the claim is they will identify who the defendants are, make contact with the defendant's insurance company, so the insurance company knows they're around. And then we'll file a lawsuit in court. Sometimes that's done immediately. Sometimes there's a delay on that for tactical reasons at some times. And sometimes some things have to be figured out before the lawsuit's actually commenced. The lawsuit is then commenced. Now, the reality of our legal system is it moves very, very slowly. So once the lawsuit is commenced, it then sort of plods along on a very slow turning wheel. Where we go through what's called the discovery process, which is where documents are collected, medical records are looked at, witness names are obtained, whatever needs to be done. Experts will be engaged during that period of time. Things called examination for discoveries are done, which is where people are questioned under oath about the claim they're making and what injuries they suffered and what has happened to them. And then ultimately, negotiations will ensue to try to resolve the claim. And negotiations pretty much go on throughout the file. The insurance company is always generally eager to try to resolve it. And of course, early in the day, they offer small amounts. And as the file progresses on and works its way through the years, their offers tend to get higher and higher. At some point, hopefully, which is about 90% of the time, they will reach a level that we're happy with. In terms of what they're offering, and then the file will settle, and that's at the point that the disbursements would be repaid. About 10% of the time, we don't reach a resolution. We go to a trial. We fight the trial, and then we get a judgment, and then the trial judgment works similar to a settlement. You get your judgment, and then you get your disbursements ordered to be paid in addition to whatever your judgment is, and then you get your money back that way. So it's a fairly straightforward process in personal injury in terms of the way it runs its way along.
Okay, great. Somebody just asked a question, is 10% standard or is maximum rate offered? No, so 10% is standard. It starts at 10%. The reason why is because there's some big lenders who actually do much more than, you know, small money. They do lend big amount. Therefore, their rate on part of their portion is higher than 10%. But 10% is what everybody is getting, at least. Okay. Okay. Next.
Okay. I sort of went through that earlier.
Yes, you did.
Again, in terms of the save files, and I think another important point, I don't know if I mentioned earlier, is that there is an insurance company available on the other side to pay at the end of the day, because you can have a large claim as an example, but you might be suing somebody who's uninsured, and therefore you're not going to get any money for it. So even though you might get ordered or theoretically should get your disbursements back, you're not going to get them because there's no insurance company to pay them. So one of the important points is not only do you have a viable claim, but that you have a viable insurance company on the other side that's going to step up to the plate and is required to pay not only the judgment, but the amount of the disbursements that are actually ordered. That is at least the criteria for the cases, again, that are people's money here would be lent on. As I've alluded to earlier, I also do medical malpractice cases. I also do product liability cases, which are sort of part of those big things you hear about down in the US, of all those medical devices that go wrong. I'm sort of part of that group. But that's a different thing. Nobody's money goes on that because those are fairly risky claims. So we call those high risk, high reward claims. We could make a lot of money on them, but we could also lose on those ones. So nobody's money goes on those. People's money here goes on the more standard, safe, more typical injury claims that we know are going to be successful at the end of the day. The only question is how much are we going to get in the settlement?
Right. Just for the fun of it, for the high risk, which we're not lending money on anyways,
Yeah.
the whatever. What's the biggest settlement you've achieved?
Oh, you can get in those ones 15, 20 million on a resolution. Particularly, it depends on, like, if you're representing a lot of people in a product liability case, like you could have thousands of people injured by a certain product that's gone wrong. And if all of them are getting an average of 50,000 or 100,000 a piece, you can see how that can add up to an awful lot of money very, very quickly.
And that's
and another one is what we call a compromised baby case, which is a terrible way to put it, but basically a birthing injury. If there's been negligence on the part of a doctor during a birth that has potentially permanently injured a baby, those are 10, 15, $20 million claims, because you've got income loss for this baby for life and potentially significant care costs for this baby for life. So those are significant claims. And the one good thing about those claims, we say they're high risk, high reward, is that they always have the money to pay. Product manufacturers of medical devices are extraordinarily wealthy, those companies. So you will get your money from them if you can prove and they agree to pay, or you can prove it in court, you're going to get paid your money. And similar to claims against doctors in medical malpractice cases, they are backed by what's called the Canadian Medical Protection Agency. That agency will pay out whatever those doctors are deemed to owe, so you can get paid on them. The problem is that they are very, very difficult to prove, very, very expensive to prove, because you need some very high level experts to say somebody did something wrong in those cases. And so you're forking out an awful lot of money to try to prove it, and you can easily lose on it. So that's why we call them high risk, high reward. If you win big, but if you lose, you can lose pretty big too.
Got it. Okay, next.
Interest on disbursement from what I'm charging? Is that what that's question's getting at, I'm assuming? Yeah. So when I put disbursements on a file and pay disbursements on the file, there's an automatic ticker, so to speak, on it that starts calculating interest at 12%. So when I recoup the disbursements at the end or settle a claim and get the insurer to pay the disbursements on top, typically I get the full disbursements plus the 12% interest charge on it as well. So there's a little bit of a amount made there. Now that's not universal. Sometimes we don't get the 12% on the interest. Sometimes they waive it for certain clients because I feel bad for them if they're really badly hurt. So some people, I don't necessarily get that universally, but we do charge 12% on it, which we're seeking to get get back from the insurer when the disbursements are recovered at the end of the claim.
Okay, so sorry, who pays the 12% interest to you? Is it client or is it the insurance?
No, it would be the insurance company at the end. So the
Okay.
defendant's insurance. So we're trying to collect it from them.
Got it.
That's the amount of interest they pay on disbursements is more debatable. They do have to pay interest, but 12% is more than they typically have to. Now sometimes they'll pay it just to get the claim resolved. But sometimes they'll get sticky on it, so they might only pay like 5% or 6% or something like that. So the interest part of it can always banter back and forth on that. And again, that's not affecting the actual amount of the disbursements because we always get the full 100% of disbursements, which is going to get recovered. It's just whether or not we get any additional interest money on top of it at the end.
Got it. Great. Next.
Disbursements, yeah, sorry. So basically, when we settle a case, so to use a very simple example, if I were to be representing you and I were to settle your claim for $100,000, and I've spent $20,000 on your claim, the insurer would pay the $100,000 for the settlement, and then they would pay the $20,000 for the disbursements in addition to the $100,000. So it's on top of the actual settlement. Practically speaking, in terms of logistically, they'll send me one check for $120,000 and you'll send two separate checks. But it's a combination of the two, the settlement plus the disbursements, and then the $100,000 is for the settlement. So that's what the client gets less what my fee percentage is of that. And then the disbursement money goes directly to pay off the disbursements. And then in this case would then come back into the my main account after that file's been settled, those disbursements are cleared.
Sounds good. Next. Interesting. How does the fund flow in and out through your accounts?
Yeah, so basically, as I've sort of talked a little bit about before, so people, when they put money in, will deposit money in, and then I will put that money out as I see fit on the files that I need to pay the disbursements on. And then when the claim's settled, then the money flows back into that account. Now the account tends to get an influx of disbursements coming in, roughly in the area of about $200,000 a month is coming back in every month, because we tend to settle somewhere around the area of 7 to 10 files a month with an average disbursement of roughly 20,000 approximately for each file. So it comes in around that level every month. So that'll be flowing back in about 200,000. Then again, money can flow out, and how that money flows out depends on what people whose terms are up decide to do, whether or not they're deciding to redeem it or renew it, or some combination of. Will depend how that money is disseminated out in any given month.
Perfect. Okay, next.
What if a case falls apart? So yeah, I on these particular ones, like the ones that, as I say, I would classify as the safe files, where this type of money goes, that's really not going to happen. That really is more applicable to the ones I talked about before, the medical malpractice ones. But in theory, just to allow for that possibility, if that were to occur, that's where after the event insurance would kick in to pay out whatever disbursements that we may have lost because of a case falling apart. I mean, even if a client were to die, as an example, during the course of the claim, the general rule of thumb is that once the person dies, the claim kind of dies with them. But we are still able to collect from the insurance company a number of small things that they were claiming, but we can always collect the disbursements back on the claim. So even if the client themselves pass away, the disbursements are still recovered from the insurance company at the end of the day. The only time I could see one of the safe files falling apart, and it hasn't happened yet, would be if a client was committing a fraud, like a blatant fraud, and they fooled me. If they said they have some kind of serious injury and it turns out they didn't, kind of thing, or they get busted by video surveillance doing something they're not supposed to do, or weren't actually there when they said they were there, or something like this. That in theory could be a case that falls apart, because you would have no claim, because literally there's no existing claim at that point. But that again is where that's really what the after event insurance is for, in situations like that, to cover and protect the disbursements in the event something like that were to happen.
Great. Okay, next.
Nice. Speaking of that,
We're gonna ask this a lot, so just tell people what happened.
speaking of death, yes. So if I were to die, what would happen is some other lawyer or law firm would assume conduct and take control of my files, and in so doing, they would be required to fund the disbursements themselves. So they would have to arrange their own way to fund the disbursements, and then they would pay my estate the amount of those disbursements from those files. So all that money that's been disseminated out on all those disbursements would be paid back in again to that launching pad account, so to speak. And would go back in there, at which point then my state administrator, whoever that may be, would then have the task of paying people out as per their contracts when their terms actually come on. So essentially, as soon as I were to pass away, somebody else steps in and pays off all the disbursements, and whatever disbursements I've actually paid would be paid back to me. And of course, that would then go into that account, and then that money would then be paid off to the people that have lent the money to me to do it. So that's how that would be handled logistically if that were ever to occur.
Okay, great. Next. So I would wish you live a very long life.
Thank you.
Your happiness is my happiness.
That's right.
Okay, next.
I don't prefer individual. I don't know if prefer is probably the proper term. I think what happened was traditionally, and I've never been a traditionalist, traditionally, it's always been banks. And then there was a proliferation of litigation lending companies, particularly in the States, who were making vast amounts of money doing these kind of things. And what happened was, I think there was a conversation where it was like, well, why couldn't individual people just do this as well if they wanted to loan money on these sort of things? And the answer I came up with, there's no reason why they can't, if that's what they want to do. And then I started to allow that and do that, and have people just independently loan money in. And then as time has passed, it just seems it works very, very well. People, I assume, I don't actually tend to meet the lenders personally, so but I'm assuming everybody's happy with what goes on, because they get the interest that they expected to get, and they get their money back if they want their money back, or they roll it over if they want to roll it over. So I'm assuming everybody's happy, and it seems to work very, very well. So I suppose at this point I probably prefer it, simply because I'm used to it now. But yeah, there are other options in terms of banks and these other lending institutions. But individuals seem to be working quite well for me, and I'm quite happy to have people making reasonable money on these loans, rather than having a bank making it, or one of these large lending institutions making the money on it. I have no objection to the small people, so to speak, making money on it too. So.
Right.
So yeah, so that's sort of how it's developed, and that's why we're at this point.
Right. I think also you mentioned like I think your law firm were also lending money onto this on files or
Yeah, yeah. I mean, they pay disbursements on files as well, right? So they have files that they're dispersing money on as well. They get their money, I think, from the bank. I think that's where they get their money from.
okay. All right. Next.
Yeah,
Yeah, we get asked
fair
this a
enough.
lot.
Yeah,
Yeah.
fair enough. And I think sort of to explain it, and so it's fully understood. The funds aren't really parked in my personal account. I mean, they are deposited in there because it is a loan that is going to me. And then I then disseminate that money out on the disbursements on these files. Now, once it disseminates through me and goes into these other files have every file has an individual trust account, and so it's going in there. So the money is actually in a trust account, theoretically speaking. It's just out on all those individual files trust account. It's not on one big trust account, so to speak. And so I think it's incorrect to say the money's parked in my personal account. It just kind of flows through it, is what it does, and then flows back into it. And then again, once it's flowed back in, then it either goes back to the lender or it reverses itself and goes back out on the disbursements again. So it's more of a conduit than anything else, but it doesn't really sit there. It doesn't do me any good to sit there in my personal account because it's not earning anything in my personal account. I'm just paying somebody to lend it to me if it's just sitting there. So it needs to get out onto an actual file. And into various files and various trust accounts on file, because that's where it's making me money, because it's actually out there.
So why doesn't money directly go to trust account?
Because it wouldn't be a trust account, because the money's being lent to me. If it went into a trust account, and it would be in trust for who? Because it ultimately works its way to a trust account for those individual files. But for me, it's just a loan to me at the end of the day.
So
And that actually better protects people, looping back to the question of what happens if I die, because if I die, then the money comes back into that account as part of my estate and is paid back out to people rather than sitting in a trust account, which would have to be a trust for some other entity, which would be a much more complex process to get people repaid if they need to.
Okay. I got this question here, which never came up before. Interesting. Okay.
Yeah.
If a lender passed away and they don't have a
Yeah.
will,
Yeah.
then can they name beneficiary as part of the lending agreement, or like when the money comes back, like where are you paying that money to?
Yeah, I mean, me personally, I mean, I'm, as you know, Cindy, very easy to deal with on things. People have switched names of people on various loans at times and wanted to go to other people, which I've not a problem with. So yeah, I mean, if a lender were to pass away in the interim, I would just need some direction as to who to actually give the money to. So long as I was satisfied that I was giving the money to somebody who has the authority to take it, so that somebody else doesn't pop up on the scene and say, hey, wait a minute, you should have given that 100,000 to me, not them. That would be the only issue that we just need to satisfy ourselves of, is that it's going to the right person. But other than that, it's not.
Right.
I don't have a difficulty with working with whatever happens to need to be worked with in terms of a difficulty arising of somebody getting paid.
Right. And I think, yes, the beneficiary can be mentioned as part of the lending agreement if that's one particular clause that we need to add.
Yeah, I mean, if somebody wants to put that in there, I mean, that's certainly not, I don't have any issue with that at all.
Right. So now jumping back to trust account, sorry, I just have a follow-up question on what you just said. So
Yeah.
is there a trust account for every single file?
Yes, every single file would have their own individual trust accounts. That's true.
Oh my goodness.
So when disbursement monies are paid in there, that's where they sit. They sit in the trust account until it's used on a file. Now, as personal injury law firms, because we tend to use the money pretty frequently, because we don't, like I say, the typical lawyer trust account is, a client pays the lawyer a retainer of like $20,000, and that sits in the trust account, and the lawyer pulls out of it as they need it. We don't do that, so it's all our money that's in there. But in theory, if I'm like going through a file and I'm saying, okay, I know on this file I'm gonna have to get some medical reports, so I know it's gonna need $20,000 in there or something like this, I will put $20,000 in there. Now it's going to go into the trust account of that file until we get the medical report, and then the money would be transferred from the trust account to pay it. To pay for that medical report. So every individual file has a trust account. The money doesn't sit very long in the trust account because it tends to get used up pretty rapidly, because I use the money to pay things, not to sort of sit in accounts. That doesn't really do me much good. It's working its way around, but it generally can't flow through a trust account.
Okay, wow. So then you have to manage like 800 or more trust account. I
don't want to manage trust accounts. So that's why I tend to be like, okay, how much does that file need? Here you go. There's the money. There's certain things. So
all right, cool. Okay. One more question, I think.
Yeah.
Oh no, we just answered that. It's the lending agreement. Okay, we answered that alive. Okay. Next, we still have
average payout settlement amount of a case. Yeah. So the first thing I always like to say here is that the actual settlement is I appreciate people are always curious about that, but it's really irrelevant to the disbursement, because even if the file settles for $1, and I've spent 30,000 in disbursements, we're going to get 30,000 for the disbursements and $1 for the settlement. So it's a bit of a red herring in terms of the actual disbursement. So long as you get something for the settlement, it is even $1, you're going to get all your disbursements paid back. But if people are curious, the average settlement is generally around $100,000 per file. Usually the average sort of settlement on the actual claim tends to average out around 100 grand per file. And then the disbursements are paid on top of whatever that settlement may be. But again, even if the settlement on a particular case was $1, you'd still get all your disbursements back.
Great. Okay, next.
Timeline. So timelines can vary. There's two things there, of course: timeline of settlement, timeline of payout.
So the reason why we have this question is because a lot of people ask about, wow, the case can take so long, but the key is to distinguish how much time the money is in there versus how much time the case takes to conclude. So if you mention both aspects, that'd be great to help people understand.
Yeah, sure, no problem. So first of all, timeline of settlement, of course, is how long the file takes to settle, and timeline of payout, of course, is when people get paid. Now, the timeline of the payout is just linked to whatever their term is on their contract, because they're just lending money to me, and I will just honor whatever term that happens to be. Now, the settlement of claims can take extraordinary lengthy periods of time. They can take 3, 4, 5, 6 years to actually settle. But the thing to remember is because I have so many files, I've been doing it so long, it's as today I've sort of used that example before, it's a bit like a train that's kind of working its way down a track. And the cars at the end of the train are at the rear, and they're going to take much longer to resolve, and the cars at the front of the train are coming up on a trial date within the next couple of months. So they're going to resolve within the next couple of months. Either we get a resolution, or they're actually going to go to court and we get a resolution that way. So because I've been doing it so long and there's so many, there's a very long continuum of these. So it's not like, and that's the other important point, of course, is that somebody's money is not going to a particular file. It's not like somebody gives me money and I say, okay, well, that's going to go to file number 32. And they're not going to get repaid until file 32 settles. That would be unworkable, because file 32 might take 2 years to settle, and they may have a term loan of 6 months that they want back after 6 months. So the money just goes into a group pool of money, and then that money is disseminated out on all the disbursements. And again, the ones at the front of the trains are paying back in, and the ones the end of the train or not, and the ones in the middle may or may not be paying back in, depending on if they're settling sooner than they otherwise would. But that money just keeps flowing back in. So it's not, nobody's money is independently linked to any particular file. It's just linked to sort of the global train, so to speak. And when the train's file settlements come in, then the payouts are generally paid out from that money flowing back in. And as I said, there's usually enough money coming in for every month to pay anybody out that needs to be paid out in that independent month.
Right. Okay. Next, and I have a question here. This is a very good question. Why lend to you, not your law firm?
The law firm wouldn't take it because the law firm goes through banks. So they wouldn't do it in that respect. And the reason why it works for me is because I have a very complex arrangement with the firm in terms of how much my fee split is on any particular case. So if, as an example, I were to settle a case that the law firm is funding, so if they funded the disbursement, my cut of the actual fee on that claim is much smaller than if I've funded the claim directly. Then my cut is much higher. So the advantage to me is that my fee elevates quite a bit by doing it this way. So by taking people's money and getting the loans and putting it onto these files, my personal fees escalate quite a bit, and that's how I make my money on these things. And the amount that's being paid out in interest on these things is much less than the escalation of fees that I'm making, which is why it makes economic sense for me to do it in this respect. I don't think the firm would have any. There's no benefit to them one way or the other by doing it. They're already funding anyway. Either whatever means. I don't actually know specifically how they fund. They've been around a long time. They may be self-funding for all I know. They're rich people, so they may be doing it in that respect. So, but they're probably got some sort of banking arrangements where they use a bank to do it, which is again the more traditional way to do it. So I don't think a firm would do it this way, quite frankly. Someone like me does, because it has this incentive for me to fund these things and get my own money onto these disbursements because of the escalation of fees for me.
Great. Actually, one related question: how long does the disbursement fund stay in a particular case? Like, how long is the money used for a particular case?
Again, it depends on how long the case lasts. Like I could fund a disbursement on a particular file. It can be years before it technically pays its way through and actually gets recouped and recollected. It depends on where on the sort of, again, going back to that train analogy, it depends on where on the train that file happens to be. The closer it is to the front, the quicker the money turns around. So I will tend to fund forward back, so to speak, right? I'll put money on the ones that are at the front of the train and then work my way back towards the rear of the train, because the ones at the front are going to return money much faster than the ones that are at the rear of the train typically.
Right. So is it like 6 months, 12 months, 18 months, 24 months, like typically?
Well, the ones at the front can sometimes be quick. I mean, they could be in a couple months, depending on what's coming up. And then the ones further back could be, 3 to 6 months, and the ones further back from there could be 6 to 8 months, and then further back from there could be 8 to 12 months. There's like a grouping that are going to settle within a certain time period, and it just keeps working its way backwards and backwards and backwards.
Got it. Okay. I know you have to leave in 20 minutes for family obligations.
My kid, yes.
So let's pick it up. Okay. Success rate of settlement.
Yeah, on these particular files, it's at the moment it's been 100%. None of them have failed.
Right.
Again, because they're pretty carefully picked as being the safe files. So they've all resolved for something, which is how I equate success rate. It's resolving for something that's getting the disbursements made. And so it's 100% at the moment. We haven't had one fail that this money is coming on.
Great. Next.
ATE insurance, for purposes of this, it covers all the disbursements that I would have paid out. So again, if a claim fails, if I've put $20,000 for disbursements on that file, that $20,000 would be repaid to me from the ATE insurance. ATE also covers some of the clients, if the client has what's called adverse costs against them for some reason, if something's gone wrong in the claim, but that's beyond the scope of what we need to worry about here. For the purposes here, it's the first thing that they cover is the disbursements that we put out on the file.
Great. Okay, next. Great question.
No, we talked about that before. The firm itself has a global policy on ATE insurance, so it's not like individual files are covered and others are not. The firm has a global policy that covers all files other than medical malpractice files and product liability files, which have a different classification number internally for us. So we know that they're apart from that type of coverage. But other than that, every other file of the firm has that AT insurance. So as long as it's not a medical malpractice file or a product liability file, they automatically are going to have ATE insurance.
Great. Okay, next.
That was sort of what I was alluding to before in terms of the fee structure between me and the firm, and why it makes why this works for me and makes sense for me, and how I make my money, which I'm sure people wonder about how I make my money on that. And that's how I make my money, is the fact that they get my split of the fee from a particular claim is quite a bit larger if I've paid the disbursements along the way than if I haven't, which is why I like to get as much as I can to try to put disbursements on as many files as I can, because that escalates how much money I make.
Great. Next. How do you maintain liquidity in the account?
Yeah, as when I first began setting this up, I put $1 million into that account to give it essentially $1 million base, so that if along the way, if there happened to be a month where the money coming in from disbursements that are being recouped is not sufficient to meet money that is going out, so people that are either pulling their money out would be the most typical one, then there's $1 million base that's in there to protect against that. And for now, up to now, that's never really been an issue. It's always hovered right around $1 million as a general balance. So it seems to me that over the years, it's always, the money's coming in is always covered the amount of money that's going out. In fact, usually quite a bit more, because sometimes that base dollar value raises up a bit, and then I disperse out again. So it's never really been a problem to maintain liquidity. But yeah, there's $1 million of money sitting in an account for that purpose, just to make sure that there's always coverage in case someone wants to be paid out and for some reason there's not enough coming in that month.
Okay. Related to that, do you have your own money invested in the, lend on the cases as well?
Yeah, I've got about $1 million out, another $1 million out on other files. Now, my money tends to go on the medical malpractice and personal injury, so I don't put anybody else's money there. So a lot of my money goes out on those. I tend to keep the safe ones for lenders here, because it's a safer one. So I do have roughly about another $1 million out, but it tends to be on other more risky files, is where I tend to be putting my money out there. And again, because I'm running the risk, and I'm the one that's going to make the big money if it sells. So I'll take the financial risk with the hit if it doesn't.
True. So all in all, you're saying you have 2 million.
About 2 million. Yeah, there's 1 million sitting in that account, like that account where people put money into, and then there's another $1 million I've got floating out around there on other files.
Okay, got it. Let's move on. Next. Will 6 months turn impact the liquidity of the accounts?
It doesn't seem to have. I mean, I haven't noted any issues at all with that occurring, because again, it's just a global fund where money's flowing in and out of. And in fact, in some ways, it actually seems to have the reverse effect, because people tend to be renewing after 6 months, and when they renew, the amount of interest I need to pay them, because it's half, is actually less, because they're renewing every 6 months. So the amount of money flowing out in a given month seems to is less in terms of the interest payments that are going out. So it doesn't seem to have affected anything. And if anything, as I say, it seems to have actually worked somewhat the other direction in terms of, seems to be less money is actually flowing back out to lenders than it was before.
Okay, next. Minimum required amount.
Yeah, I kind of made an arbitrary decision of $10,000, and that was really based on the theory of what makes logistical sense. If it's less than that and gets into very small dollar values, it could just it becomes a bit of a logistical nightmare if there's a lot of them. Every 6 months they come up, and then I have to write a check And the checks are relatively small, and then they have to go out. So it can just get to be a bit of a logistical nightmare. So we sort of just made a decision that, just keep it at a minimum of $10,000, because at least that way I had to put a cutoff there somewhere. Otherwise I could get a whole bunch of very, very small ones, which would be very, very difficult to maintain and manage and keep track of, quite frankly.
Okay, last one, and then we're gonna do open mic before you go. Yeah. Okay, your most recent number of files, like.
Yeah, so basically there's, as we discussed before, so there's about 300 that are actively funded right now through lenders' money. There's about 400 more that could be. They meet the parameters of being the sort of the save files. So there's roughly about another 400 files, again, an average of about 20,000 per file, that could still be have money dispersed out on them. As it works right now, of course, is, if one of the 300 resolved, money's paid back in. If the person doesn't want the money back when it comes back in, then it flows back out, and then I'll get one of those 400 files using that money. So that 400 works its way down, will work its way down over time, with the 300 ones continuing to settle. But at the same time, some of those 400 may settle before I get an opportunity to do that. And then for me, I've lost an opportunity to make better fees on them. So it's advantageous for me to try to get money to sort of disperse out on those files as well, to try to get them at the end of the day. So there's about 400 still out there ready to go. And then the files above that, when you get into the sort of over the 800 part, when you get over basically anything over 700, that's where you're getting into the files that don't really meet these parameters. You're getting into the medical ones, or the product liability ones, or ones that are more risky and wouldn't meet parameters, and I wouldn't put somebody's money on those ones.
Great. Okay. So the last question, not the last question, but the last slide is our contact information. We help Darren do all the paperwork. So if you're interested, reach out to us. We'll organize everything. So that's our QR code. That's our email. Just reach out to us, and we'll get everything going. Okay. So open mic. If anybody has questions, I see one here, so I'm just gonna read it out. But if you guys wanna open mic, talk about anything, we have 10 minutes left. Any questions, just type it out or just raise your hands, okay? So this new question here is, how does the taxation work? Okay, so I personally claim it as interest income through either corporation or personal, depending on which entity I lend money to Darren. But you should really consult your accountant for that. So everybody's situation is a bit different, okay? Okay. Any questions? Anybody want to do open mic? Anybody wants to raise your hand? I mean, we addressed quite a few questions along the way. Wow. Okay.
We used to explain things so well.
Yeah, I think so. Even I learned a thing or two new, right? Yeah. Yeah. Okay. We'll wait for a few minutes, and then I think we're good to go. So we just process the new batch for you, and I think there's also a new batch for you coming up.
Okay. All right.
Yeah.
Even if somebody has a question about how claims work generally, if somebody's curious, feel free to fire a question about that.
Yeah. So, well, while we're, I guess, waiting for people to come up with questions, if anybody wants to speak about anything. So Darren was well, I guess our relationship ended, right? Because like the case concluded, so I can share that. So Darren was my lawyer before, like many years ago. So that's how I'm like, oh, this is how it works. Interesting, because I didn't have to pay a cent to hire Darren for years down the road for him to service me, I guess. And he bought all the reports. He flew me all the time to, a court or whatever. So that's how I came to understand, like, this is how it actually worked. So for me, it's very easy to accept the concept. Okay, somebody's asking, how much is my firm charging to be the go between lawyer and the lenders? Okay, number one, we're not the go between the lawyers and lenders. We are solely helping Darren, the lawyer, do the paperwork. So we only charge Darren. We don't represent lender and we don't charge lender. Like the 10% you see is what Darren's willing to give out. Like you get that 100% of the 10%. And if you put more, there's more. So number one, we're not a go-between. Number two, we're just helping Darren do the paperwork and helping Darren to follow up with you guys. And for signature, to sign the contract, we do the paperwork for Darren. So we don't charge lenders. We only charge Darren.
I end up footing that bill, so it's okay.
Sorry?
I end up footing that bill. So
Yeah, that's right. Right. Okay. Okay. Any other questions? Okay. I think that might be it. And you got 5 minutes to organize yourself for your family obligations.
I can go get my kid on time. Yeah.
Yes, that's perfect. Thank you, everyone. Thank you, Darren, for your time.
Okay,
And
thank
thank you
you.
for spending the evening with us. I hope you learned a ton. And hopefully everybody can make some money.
That's good. Thank you, everyone.
All right. See you guys.
Bye.